Hi, I'm Wayne Zell. I'm an estate planning and business planning attorney with over 25 years of experience practicing in Virginia, Maryland, and the District of Columbia. I'm discussing the basics of estate planning, and now we're going to talk about revocable trusts. We talked about how it's important for everyone to have a will, but wills may not be enough for you. For example, wills may not properly dispose of your property. It may not effectively cross state lines. Wills don't become effective until you die. So there are a lot of issues that you need to take care of in your estate planning while you're alive. Importantly, it does not protect against what we call living probate. So if you had a will, but you become incapacitated, a court may need to appoint a conservator. A will may not properly protect your children the way you want it to. A will by itself guarantees probate, which varies from jurisdiction to jurisdiction. This may mean costly administration, and in some cases, probate taxes must be paid. Your will becomes a matter of public record, which means that anyone can gain access to your records after you're gone. There's also the possibility of what we call ancillary probate. That means that if you have real estate, say in Maryland and Virginia, you may have to go through probate in Maryland and Virginia. Wills also are more easily challenged by your heirs than trusts are. And wills do not control most property. For example, jointly owned property passes outside of the will. A fully funded living trust, on the other hand, is like having a packed suitcase for a trip. It holds property for the ease of transfer to your heirs and your loved ones. A revocable living trust appoints a trustee, which is you, to manage your own assets. And it gives you the ability to appoint successor trustees in the event you become disabled or you die, which can be any individual, including your spouse or set of individuals, who is responsible for managing your assets during your lifetime and following your death. The trustees can be replaced as necessary due to their death or change in circumstances. The living trust ensures long-term control over all your assets. You set the rules of what happens while you're alive but unable to manage your affairs, as well as inheritance upon your death. You set the rules that your successor trustees have to follow. You can set the guidelines for your own care in the event that you become disabled. A trust can allow you to plan for many, many different situations. For example, you may have a child with special needs, or you may have pets that you want to take care of. A trust can also anticipate what happens upon the remarriage of your spouse. A revocable living trust also can allow you to do charitable planning. You could make a specific bequest to a named charity in your trust. If you've got special religious or value-driven desires, you can include incentives in your trust. For example, if your child graduates with a particular grade point average or is gainfully employed and achieves a certain modicum of success, you can pay out a reward from the trust for achieving those goals. And you can leave guidelines for your trustee. Revocable trusts are also easily amendable. And lastly, revocable trusts are a very convenient vehicle for maximizing the use of tax deductions and exemptions that we employ for gift and estate planning purposes. So you can see why revocable trusts are beneficial in achieving your estate planning goals. But that's only part of the puzzle. Up next, we're going to talk about making sure that you've cared for yourself during your life if you become disabled or incapacitated.